Court's now back in session. Y'all can be seated.
All right, we are ready to take up whatever
Recording in
motions.
progress.
Yes, Your Honor.
All right, Mr.
Your Honor, it's our contention that the defendant's confession has not been shown to be trustworthy. Your Honor's heard testimony at trial in motions that there's no physical evidence to support the portion of the confession where our client says he beat Joe Clyde for 15 to 20 minutes in the living room and on the coffee table, opening up a wound on his head that led to blood running down both sides of his face and blood on his leg from being thrown against the coffee table. There's been no corroboration that he took the child, put the child in the car, left the residence, took the body out in the field using his wife's cell phone as a flashlight, then returned home and got back in bed around. The child is even dead. There was hearsay that came in where an aunt expressed her opinion that he was dead, but the witness today, Alex, did not testify that he was dead. He did not testify that he saw what happened in the living room, that he came in after the fact and saw his father pick up Joe Clyde Daniels and walk away from the residence. So we submit the corpus delicti has not been shown. The confession and statements, extrajudicial statements, have not been corroborated. Even the TBIs acknowledged in the affidavit on the search warrant that they don't believe he took the body in the trunk of the car and took it off. I would submit it. Even Alex's testimony today did not say that he took the body, put it in the trunk of the car, and took the body off and disposed of it. So those clearly have not been corroborated. There was no blood in the vehicle, no blood in the residence, nothing to indicate that when our client said he beat this child for 15 to 20 minutes, opening a head wound and causing blood down both sides of his face, nothing to show that is trustworthy. He gave various statements about placing the child in ponds. Ponds were drained, no body, nothing to corroborate that. He said that he took the child out on a log road. All those areas were searched extensively. Nobody was found. And the Bishop case, of course, says if it involves a tangible injury, the state must provide substantial evidence tending to show the defendant's statement is trustworthy. And the state has not done that in this case. They've introduced no evidence that substantiates that our client beat the child to death in the living room for 15 to 20 minutes. No evidence to substantiate that he placed the body uncovered in the trunk of a car, carried the body off, and used his wife's cell phone flashlight as a flashlight to get rid of the body. In fact, the courts heard testimony in this case in the motion hearings that there was no evidence that Crystal Daniels' cell phone left the residence at all. So those are all statements, extrajudicial statements that aren't corroborated. He said he threw the child in the Duck River. We now know that TBI doesn't even think the car left during that time. So that's not corroborated. Mr. McCormick said that he saw someone, and where exactly on Garners Creek Road is a question, but the person he saw had a skeleton on their shirt, and it was not a big person wearing a green alien shirt. So that also indicates that the confession is not trustworthy, because our client would have already been in bed At the time, Mr. McCormick saw the person wearing the skeleton shirt down the roadway. The statements about, I think the testimony had been in the motion hearings up to maybe 6 different locations that the child was placed. None of those panned out. There was no evidence that supported any of those statements. And so we would ask that the court exclude our clients, all of our clients' extrajudicial statements, that they were not corroborated. The case law cited in the motion provides cannot be corroborated by miscellaneous facts. The state has to corroborate the essential facts of the confession. That he beat him to death 15 to 20 minutes in the living room, opened up wounds on his head and on his leg, then immediately carried the body off in the trunk of the car, got rid of the body using his wife's cell phone light, then came back home and got in bed. And I submit the state can't cite one piece of evidence that corroborates that that's true. They even believed that he buried the body in the yard somewhere. So they were admitting that those essential facts are not true. So I'd ask the court to exclude all of his extrajudicial statements as being uncorroborated in this case. Now, it doesn't mean that the state doesn't still have a case, because they've got young Alex who's testified, but they shouldn't be allowed to introduce extrajudicial statements that we know are false. And clearly that confession was false.
What about the statement that your client allegedly made voluntarily to his father in the presence of law enforcement after he had called and asked him to come and take him and let him show him where he was? The motion hearings that we've had are that he has voluntarily told his father, "I beat him."
Yeah, I'm not talking about voluntariness. What I'm talking about, that is an extrajudicial statement that has not been corroborated. Everything he said out of court, whether it's to his dad or other officers, or
You don't think Alex's statement, that the testimony today that he saw his father beating the child he testified that he saw him beat him. Is that not a corroboration?
I didn't recall him saying he saw him beat him.
He did.
Your Honor, his testimony was he heard a noise and he went in there.
He's talking about, we can have, if we can find it, we can always bring it back, but my recollection was that he's testified that when he went and told his father today, that when he told his father that Joe had peed on the floor, that his father came in, or Joseph had come in, and he beat Joe and put him back to bed.
No, he didn't testify that.
Okay.
He testified that he spanked him or whipped him. He did not testify he beat
He
him.
used the word beat, according to what I recollect.
I'd ask that be pulled back up, because I think that's a
We'll
mistake.
decide that. I'll base it upon my recollection, not have to prove anything to you, but I will base it on my recollection of the facts and my notes from that. But, all right, anything else that you wish to offer?
Well, just one thing. In that testimony, whether he said whip or beat, he put him back in bed and went to sleep. So that in no way corroborates that he beat the child to death, because the child got back in bed and went to sleep. So I don't think that corroborates that he beat him to death. Alex did not see him beat the child to death in the living room. He heard a noise. He waited a while. He came in and he saw his dad pick up Joe Clyde Daniels.
We first said he saw him laying on the floor.
On the floor, picked him up, took him outside, laid him on the ground, then picked him up and carried him down Garners Creek Road. But nowhere did he testify that he saw his father beat the child to death. Now, that is circumstantial evidence that he sees the body laying on the floor and then he sees the body laying in the yard. I'll submit that circumstantial
And we
evidence.
charge the jury all the time that a fact can be proven by direct evidence or by circumstantial evidence, and that the law doesn't presume that direct evidence is necessarily better than circumstantial evidence. That's the law we charge a jury to decide a case. So
I understand. What I'm trying to do, Your Honor, is lay the groundwork for the jury charge that I'll be requesting in regard to that. I admit that that's strong circumstantial evidence. I'm just saying, to Your Honor, there was no direct evidence, no direct testimony that he saw him beat him to death.
I understand. Thank you, Mr. Lockhart. Mr. Crouch?
Judge, for purposes of meeting the Bishop standard, which is the modified trustworthiness, I think Mr. Lockhart just made my argument because he admits that the circumstantial evidence is strong.
I doubt Mr. Lockhart would agree with you, but I understand your point.
And that is my point. We have an eyewitness who has testified that he witnessed Joseph Daniels beat Joe Clyde, and then later he heard a loud noise. He went into the living room and he saw the defendant standing over the body of Joe Clyde, who was on the ground. Then he demonstrated how the defendant carried Joe Clyde's body out of the house in his arms. Alex then testified that he saw him lay his body on the ground, later walk him down the driveway and then down the road. Not only that, Your Honor, if you look to the statements of the defendant, the extrajudicial statements in the hearing of his confession on April 6th, the defendant specifically says, Alex saw everything. Not only does he say Alex saw everything, later in the evening, he says Alex is a trustworthy boy. We told him not to lie. You can believe what he says.
No further argument.
All right. Let me, for the record, address the following. The State versus Bishop is a Supreme Court case that we keep talking about that set forth the modified trustworthiness standard. There are two different standards for the record that this court has to consider in the admission of any sort of confession or admission. The first is the voluntariness of such a statement. I have already had a hearing in which I found that the statement of the defendant in the so-called confession and all of the other statements that he made were voluntarily made and were not the product of coercion. So that issue has been resolved by the court's prior ruling. The second matter that I am required to address today is the Bishop standard that was set forth in this 2014 Supreme Court decision. That in that decision, the Supreme Court modified the requirements for the introduction of a confession and the corroboration of a confession of a defendant, the aim being to eliminate confessions of individuals that are completely untrustworthy and have no other corroboration to them other than the confession of someone to a crime. The Supreme Court in the Bishop case makes pretty clear a couple of things, and one of them, when a crime involves a tangible injury, the state must present independent prima facie evidence that a loss or injury actually occurred. Unlike the traditional corpus delicti rule, the state is not required to demonstrate that the injury resulted from someone's criminal act, nor must the state link the defendant to the injury. Whether the charged offense involves a tangible injury, the corroboration rule requires the state to introduce substantial evidence, independent evidence, that the defendant's confession is trustworthy. To establish trustworthiness, the state's independent evidence must corroborate essential facts contained in the defendant's statement. Mr. Lockhart takes that statement in the Bishop case and applies it to everything that the defendant said in his confession. That's not what the Bishop case says in this court's opinion, with all due respect to Mr. Lockhart. For example, in the Bishop case, the Supreme Court says, for example, independent corroboration of one key part of an extrajudicial confession or admission may corroborate the entire statement. And they cite the United States versus Brown, a federal court decision in that instance. So, looking at that, the Supreme Court further says in Bishop, thus to satisfy the modified trustworthiness standard, the state is required to, 1, corroborate the fact that someone died, and 2, establish the trustworthiness of Mr. Bishop's confession. The standard does not require independent corroboration of every element of the crime. That's the Supreme Court's ruling in Bishop. So it's not required that the state in this case corroborate every element of the crime or every element of the defendant's statement. In our subsequent cases that have been reported, the State versus Hill, which is an unreported case that I think I've cited before, it's a 2017 Westlaw 5324181, a 2017 Court of Criminal Appeals decision. The court there talks about the modified trustworthiness rule. The modified trustworthiness rule requires substantial independent evidence to bolster a defendant's extrajudicial confession or admission. The state is neither required to demonstrate that the injury resulted from someone's criminal act nor link the defendant to the injury. state must introduce substantial independent evidence that the defendant's confession is trustworthy, which is accomplished by presenting independent evidence corroborating the essential facts contained in the defendant's statement. The court noted that, in citing another case, the court noted that independent corroboration of one key part of the defendant's statement might corroborate the whole statement. The court determined that another method of bolstering a defendant's admission is to present independent evidence that parallels the defendant's confession or corroborates the defendant's account of what happened immediately before or after the crime. In State v. Sykes, which is a 2018 Supreme Court decision, the Court of Appeals, Court of Criminal Appeals, I think this may have been Judge Woodall, I'm not sure, but actually this is Robert Holloway, who authored this opinion. He states that substantial evidence and the modified trustworthiness standard, substantial evidence is evidence that a reasonable mind could accept as adequate to support a conclusion, evidence beyond a scintilla, and he cites State v. Clark, a 2014 case. The corroboration requirement is a low threshold. Its purpose is twofold: to weed out false confessions to non-existent crimes by requiring some independent evidence of the injury incurred, and to weed out false confessions to actual crimes by requiring some independent evidence that implicates the accused. The standard of proof required to clear this hurdle is even lower than the preponderance of the evidence standard. So that is the law that I am required to apply to this case and to these facts. In this case, we have the testimony of an alleged eyewitness, Alex, who states that he was there and that he saw the defendant come in. In my notes, I have gone back through my notes after we had this issue, and my notes that I wrote down were specific. That he went and told the defendant that Joe had peed in the floor. The defendant was in his room. He and Crystal were both awake, and the defendant went into the room and beat him. Those are my notes that I make contemporaneously. I'm not saying I'm 100% all the time, but that's what I'm basing my decision upon. In any event, we have the testimony of an eyewitness. Alex states that he saw him beat the child, that he went on back to sleep, and he later, in the middle of the night, heard a loud bang. He waited a little bit to let things quiet down, that he walked out and saw Joe laying on the floor. He then saw the defendant carry him out. More importantly, in this court's mind, Alex's testimony was that he saw Noah standing and also being able to view what had taken place along with Aunt Joyce, and that he saw both of them and that they had an opportunity to observe, and that he saw the defendant carry Joe out the door, and that he laid him at the back of the car, and that in fact he instructed Alex to help him with this situation and threatened him at some point, made him help him, that he opened the door to the car in the trunk. And at one point, if you notice in one of his statements at the Child Advocacy Center, Alex stated that the door to the car had been opened. In his statement today, he testified he opened the door and popped the trunk on the car. He then says the defendant picked up Joe and walked him down the road carrying the child. The defendant's confession states that he beat the child and that Alex witnessed it. That's, in my opinion, a corroboration of that statement by the defendant is corroborated by Alex's testimony today. Alex's testimony corroborates the fact that Noah witnessed this, and so the excited utterance that was allowed in at a previous hearing of both Noah and Joyce, who he testified that Noah certainly had the opportunity to see what took place, and that when Noah comes in, and that argument could be made to the jury that Noah's statement was either a question or a statement. He either says in a question form, is Joe dead, is Joe dead, is Joe dead, or he said in a statement form that Joe is dead, Joe is dead. But anyway, I allowed it in as an excited utterance. Apart. Based upon all those facts, and the fact that the child, in response to the state's question, stated that the last time he saw his brother alive was on April the 3rd, and the fact that the child has never been recovered and that threats have been made, I believe that there has been sufficient corroboration of both the corpus delicti, if there is, that circumstantial evidence of the death of this child. As I explained to Mr. Lockhart, and Mr. Lockhart agreed, our law provides that any fact, can be proven by both direct evidence and circumstantial evidence. We charge jurors day in and day out in jury trials that direct evidence is not necessarily better than circumstantial evidence. Our law provides that either fact can be sufficient to support a conviction if it is convincing enough. And that's what this all boils down to. This is all going to boil down to whether the jury is convinced by the evidence before it. But as far as corroborating the confession, this court finds, and as a matter of fact, that the evidence presented thus far does provide more than a scintilla of evidence that there was, in fact, a homicide, that the child was, in fact, you can certainly concur that circumstantial evidence of his death would be the fact that he was laying on the ground, picked up, carried out, laid on the ground, picked up, carried off down the road by the defendant allegedly, and that he's never seen again. And he testified the last time he saw his brother alive was April the 3rd. That was in response to the state's question. Based upon all of those facts, it is this court's opinion that the corroboration under the Bishop rule has been met, and that the confession and all extrajudicial statements of the defendant are admissible in the state's case in chief. And it is my ruling.
Thank you, Your Honor.
Thank you. That will conclude our business today, and we will adjourn for the day until 8 o'clock tomorrow morning. So.
All rise. Court adjourned.
Recording stopped.
See you tomorrow, Bill.
Joe? No, Zach, Joe's getting kind of old.